feel a sense of frustration in the hotness of the room, etc. Keep that feeling, because that feeling actually will lead you to feel angry or disappointed, which will fuel backlash against the conference as such. And that is no coincidence, precisely the theme we'll discuss in this panel. I'll just so everyone can slowly make their way to their seats. So we've heard about sort of the legal setup, how rules, how regulation changes in response to backlash. This panel will be slightly different in the sense that we focus on the backlash as such. So better understand it, see how we can use law to work with it, or how law is actually very much not able to work with it. And we will doing that with three great speakers. I'm Wiebe, Hommes, by the way, I work here. We'll begin with James. Was already on the list. James Patterson, who is an associate professor at Utrecht. Your research focus very much on, well, a lot of things, to be honest, but sort of the political setup, particularly dealing with, well, backlash as a phenomenon. Most recently, you've looked at sort of how backlash as a phenomenon deals with climate policy. So today you'll begin sort of talking about what is backlash. And I think it's a very nice setup. So we begin quite broadly and then we move to more specific elements. We'll go with Giacomo, who has changed roles from chairing a panel to actually speaking. Giacomo is assistant prof here at the University of Amsterdam. You know him because we put this conference together. Focus very much on the study of markets, I would say in a very broad sense, cultural, societal, and also has received an EOC grant to study the concept of loss and how loss relates to backlash and how to govern it. So that will be his focus today. So the governance of loss, introducing us to his project and relating it to how that relates to backlash. And finally, we have Lola Avril, Professor Junior at the University from Eastern Finland back to Paris. And your research very much about the non-state actor, if I may sort of summarize it that way. The construction, as I would say, the functioning of EU law. And today is also precisely about that. So the role of private actors in, well, the sort of regulation of EU law and how that actually might make the EU regulatory regime vulnerable to backlash. All these teasers aside, my job will be very simple, but very important. That is keeping you all to 10 minutes. I'll be very firm. James, apologies.
Okay, thank you so much for the introduction and also very much for the invitation to be here. Such a great panel with three presenters really speaking to each other. I think I've never experienced such a nicely integrated set of topics. So I'm coming from let's say a political science and policy studies, environmental politics perspective, so not a legal perspective. So I hope that I can, in some senses, make a bit of a bridge, but just bearing in mind that I'm coming a little more from a policy angle. So we've been looking in a project that I've been working on for the last few years or so on the topic of backlash to climate policy and trying to explain that as a so that's what I want to talk about today. Trying to explain, as Wiebe mentioned, what is backlash itself and how can we understand how and why it arises and when it arises and what can we learn from that policy strategies for advancing issues like climate and environmental policy that can obviously have a lot of urgency behind them and can be pretty dangerous. So essentially, it's beginning with an empirical problem or an empirical observation and trying to translate that into a conceptual problem, asking the question, what's going on and how can we understand this? So we obviously see backlash being talked about more and more. And in a sense, there's a growing litany of cases of backlash across climate and environmental policy in all sorts of different areas and scales. which at its core, you could say, challenges these assumptions about what will publics and societies accept in terms of ambition and pace of change, which is really in conflict with the idea that urgent climate action is needed. And the longer you leave it, the harder it gets, the steeper the curves need to be to decarbonise. What do we then do about that? How should we think about that? And I guess the assumption or the idea behind this, the motivation, is that by trying to better understand why backlash arises, we might be able to somehow navigate those challenges, hopefully a little better. One of the curious observations, I think, is that backlash doesn't always happen. It might or it might not happen. And sometimes it happens to a relatively small policy change or policy development. And sometimes something that's relatively larger doesn't trigger backlash. So there's a bit of a puzzle there, and that's what we are tackling. So to begin with what we mean by backlash, this is a sort of definition that we've kind of put central to our project, that it's an abrupt and forceful negative reaction. It involves a significant number of actors that are trying to reverse the policy or political development. So in a sense, it has some impact on the level at which policy is happening. So it's not just an isolated protest or some isolated discontent that doesn't matter. It has some currency to those who are the policy proponents, something forward. And it can involve mass publics, political elites, organised interests in all sorts of combinations. It might or might not lead to policy repeal or rollback. So what that means is that we try to approach it as a reaction. So it's a bit of a tricky phenomenon to try to get our hands on, but we're trying to sort of explain when do these contentious reactions occur without assuming that they necessarily lead to policy reversal or rollback, instead making that more of an empirical question. Under what conditions does backlash lead to policy reversal or not? It's not necessarily just something that's anti-progressive. It could happen in any direction. We see it again as a societal reaction that could happen to any kind of a policy push in any kind of normative direction could lead to a pushback. And we also there we go. We also are at pains to say that we should not equate it with right-wing populism too quickly, but instead make that an empirical question. In what ways and when is it linked to right-wing populism and when is it not? Because often there might be a broader range of actors involved responding for all kinds of different reasons. So by calling it right-wing populism too quickly, you close down the conversation about what's actually going on. We also say that backlash can involve both institutionalized and non-institutionalized politics. So it can be arising through political parties and voting and that sort of thing, but it's also very much, of course, involving protests and demonstrations and other forms of discontent. There's a lot of variation in different cases. That's a real challenge to get a grip on. We try to focus on policy. So you could think about backlash to all kinds of different phenomena, and often all this is conflated together. We've got backlash to globalization and cultural change, and backlash to a specific decision by a government or a policy. And we say, okay, let's focus on policy specifically. And within policy, we focus on what we call hard policies. So regulation, taxes and pricing, phase outs, the things that compel behaviour among target groups and could be contentious. So what I want to do is just mention three different ways that we've sort of, let's say, tried to probe what's going on here and how we might be able to explain it. So the first step was thinking about the role of contested legitimacy as central. The idea being that sense of contested legitimacy in a sociological sense is quite a reactive force. It's something that when people perceive that there's something fundamentally wrong about what has been done or what has been attempted, that could be a real motivator of grievance. So this was sort of one, let's say, a conceptual pathway where we're trying to sort of theorize how legitimacy arises and then it's backlash. Being a little more empirical, we looked at 3 cases qualitatively with a sort of a framework of some conditions under which we might expect backlash to arise. And we basically looked at economic, cultural, and what we call practical conditions. And they were relating to costs, but also sort of cultural and identity threat, but also just the difficulty of applying, in a sense. And then we sort of tried to look at direct impacts, relational impacts, and impacts in their context. That's a little bit the thinking behind this table. And then we tried to test this idea looking at a few different cases of different kinds of what we might consider to be backlash. So in Canada, quite an extreme response among provinces to a national carbon pricing scheme. In France, the Yellow Vests case, which is well known. And then also in Mexico, sort of an eruption of discontent to the removal of a gasoline subsidy in the context of a carbon tax. And so I won't go into these now in the interest of time, but just to say that was sort of one way that we tried to probe is conditions to get a little bit more traction on what that might look like. And then another piece that we've done is doing a qualitative comparative analysis. So it's not large N, it's not small N, but it's medium N. But here we tried to look at a systematically sampled set of OECD policy cases of the presence and absence of backlash, and then trying to look at under what conditions do we see backlash arising. And essentially what we saw was it arises when there's a sense that policy is too demanding. So that as perceived by target groups, policy is too demanding, and a sense of unfairness, but then coupled with different conditions in different cases. In some cases, maybe that's coupled with a highly polarized environment. In other cases, it might be coupled with a lack of concern for climate change. And in one case, coupled with the presence of information provision, perhaps making that more salient, making costs salient to. So, what we're sort of where we come to at this stage in the project, the implications is that backlash, we would argue, is a very complex socio-political dynamic. It's very multi-causal and contextual, which makes it hard to predict, but also something that I think we should not be too quick to just say backlash is happening or taking for granted what that might mean, but instead it's something that needs real attention in each case that you might look at it. We would argue that it's an unruly concept and an unruly phenomenon. In a sense, the closer you look, the harder it gets to understand what's going on. Things become really ambiguous because you start to see more and more texture about why people are responding and all the different kinds of social and political dynamics involved. So from a distance, it might almost like a cloud, I think sometimes. From a distance, a cloud looks very solid, and then the closer you get, the more fuzzy things are, and you start to realize where are the boundaries of what seemed solid from a distance. And we could, so then there's questions. Do we see it as a reactionary form of political behavior, a cultural backlash, so to say? Or is it about interests and counter-mobilization to defend interests? Is backlash emancipatory? Does it bring marginalized groups or marginalized concerns to the surface? Or is it in fact just ordinary politics and we sort of give it more attention than we should? And all of these different explanations have different implications for how we might think about policy. But I'll leave it there because I'm 45 seconds.
Thanks. This is the spirit we need. Precisely those issues are things we can get back to. And we will get back to, obviously, in Q&A event, because I think you laid groundwork for future discussions. And yeah, so let's come back to that. I'm looking at Lola and Giacomo. Maybe Lola, if you can take this further. That's up. Yes, indeed. I think it ties neatly into elements, no? Because backlash is something which is not sort of a natural phenomenon. It needs um, things to happen. I think that's what you can sort of really tell us and buy into James' story.
Yeah, exactly. So thank you, James. It was very clear, and I think it leads to my presentation. So what I wanted to do here is, I think Giacomo called me because I wrote this editorial in ILO about the deregulatory agenda. But the thing is, I have been working on regulation and private actors. So I decided to look at the current moment at the EU level, and perhaps do some self-reflective thoughts on it, and how also to understand how it shows some of the myths I have and have been living with, and that have underlined my research. And perhaps the current moment is showing these myths that I was living in with. The first myth is the role of law in EU legal integration. And the second would be the place and position of private actors in EU integration. So it's really like looking at the current backlash with Gibe perhaps, but looking at the current backlash, so the different omnibus directives, the withdrawal of legislative proposals in the last 2 years, we can see that, of course, there have been different causes, and we have seen this in the keynote, like political or geopolitical causes. But what I wanted to ask today was, how can political sociology also helps us to understand what is happening, and also how adopting a long-term view, long-term analysis can also sort out the impression of rupture, of discontinuity that we have, and how perhaps this is actually more in line with the developments of the EU regulatory states in the last decades. So what I do basically, and I hold a chair on regulation and non-state actors, so that's perfect for the topic, is studying first the EU governmentality. So governmentality as a way, this Foucault concept, as a set of institutions, procedures, analysis and reflections, calculations, tools. So which is very useful for political sociologists or political scientists, because it articulates a theory of power and the states, and a theory of practices of governments. And I add to this the study of the actors that are actually doing these policies, and looking specifically on the public-private divide, circulations between the public and private divide, interactions between the public and the private sector, and the role of non-state actors in the making of the EU regulatory state. So to start with, of course, and we have been we talked about that a few times now, we have this theory of the regulatory state as a new role of the states in the economy, emerging in the 70s, being thriving in the 80s with the work of Domenico Maggione. But what we've seen also in recent research, and less recent, but is the role of law and lawyers, the EU being a legal construct, and the role of the public lawyers, judges, lawyers from the Commission, with Antoine Vaucher and Dan Kellerman, but also private practitioners with Tommaso Pavone, or my work on business law firms investing in competition law in the 1970s, judicializing administrative procedures, etc., etc. And the second thing, so the first conclusion of this body of work is that the EU regulatory state is a co-construction between lawyers, private lawyers also, and the administration. But we also have another body of research telling us a different story of co-constitution, which is a co-constitution between the Commission and the private sector, private interests. And this is a very, I put it there because I think it's less well known in legal scholarship. Is a work by Sylvain Laurence on lobbyists and bureaucrats in Brussels. And he shows really the active role of the Commission in structuring private interests, structuring private interest groups, structuring European federations of industries in the 70s and in the 90s, picking them picking them as their main interlocutor to build policy, to make regulatory policies. So we have here then two sides of the story, one of the co-construction between law and lawyers and the EU administration, and one of the co-construction between the private sector and the administration. Then we have the 1990s with the transformation of the what we can call it the post-regulatory states or new regulatory states with the agentification. We've also been seeing this a few times today. And what is happening there is, with regard to the relationship with the private actors, is this participatory turn, meaning that interest groups gain access to new stages of the legislative process, especially through the idea of the generalization of the public consultations in the 2000s. Of course, it existed before, but it's generalizing that at every step of the legislative process, there should be consultation, there should be access for interest groups and civil society organizations to this legislative process. The second thing that is happening at the same time again is this whole body of transparency policies, ethics policies, etc. And we've been studying them with a project that we had with Emilia Corqueao called Revolve, where we were looking at this transparency policies, ethics policies, and our conclusions was these policies were mainly acting as legitimizing tools for the interactions of public and private interests, legitimizing revolving doors, for example. We studied the ethical committee that was authorizing former commissioners to go to the private sector. It always authorized commissioners to go to the private sector. Its role is a facade role to just show that something is done to control the public-private divide. So there was here two transformations. One about the access of these interest groups to the regulatory state, and second about this public-private divide, which was blurred, perhaps almost, where circulations and were legitimized by these transparency policies or ethics policies, meaning that instead of a co-construction story, what comes from this body of work is more an interpenetration of public and private interests. So that's where I was, and then I decided to look at this current moment where, so what can we say about this deregulatory trend? Is there a deregulatory trend, etc.? And for me, it just opens three questions that are yet to be researched. The first one is perhaps I've lived with the fact that the EU integration meant more regulation, even if it was different regulation through agencies, new bodies, etc. But for me, integration meant more regulation. Is that the case? Can we imagine more EU integration with less regulation, etc., etc.? So how can we revise our theories of EU integration? The second myth that perhaps it's questioning is law as a regulatory tool. And here I think there is a call for papers that has just been published by Alberto Alemano on something similar, like how law can be used to deregulate. And here the omnibus legislative tool is a very interesting one in our case. So that's and so how law, the EU regulatory state that was seen as a legal construct, how also a EU state with a deregulatory agenda can go hand in hand with law and lawyers. And the third myth, perhaps, is more like an institutional myth, is less, I think, scholarship myth or doctrine myth, is the idea that we had that the open access to institutions means balanced interest representation. And here it's clearly what we have seen with Antoine Vaucher when we were looking at the Qatargate, for example, and trying to come up with some policy propositions. We were calling for a new art of separation between the public and the private sector, and how this institutional myth here was to this openness would lead to a diversity of interests listened and represented at the EU level. That would be all my open research questions, and I think I'm 30 seconds. I was very.
Thank you. Time, so So don't feel rushed there.
Yeah, I'm sorry.
There is some room for leniency. And also, yeah, these myths are also inviting. We will have quite some discussion afterwards because my personally I have a lot to say about all these myths. Anyway, Giacomo, if you can sort of help yourself to your presentation, that would be fantastic. I like how sort of the presentations talk to one another. So we have the cooptation of, in a way, private business interests at the table, which then invites a specific kind of backlash, because who gets to be at the table? And maybe now we move to people who are not necessarily at the table.
Well, thank you, Wiebe, and I must say that my work is inspired by the idea of backlash. But first of all, it's a research agenda. And it's more about, the legal accommodations that may be responsive to those that we see as sort of the actors, putting in place the backlash. Sort of, I will present from a project that I'm about to start, a preliminary conceptualization of this idea of governance of loss, and as a way to both, understand the backlash, not in an explanatory way, but more in a sort of, analytical way, and as a way to potentially remedy. I mean, this is a big claim, but let's see where we go. So the governance loss. One of the concerns that animated this project is indeed the context of backlash, which now I'm afraid I use in a much more rudimentary way to indicate a challenge and attacks on liberal values, EU law and institution, technocratic, non-majoritarian governance. That's sort of. And especially I've observed in my own work, there's sort of reaction against, for example, EU rules that have a liberalizing orientation, for example, internal market and competition law, which is sort of aligns with the rise of far-right politics. And I have read and sort of drawn explicitly on a particular sort of stream of political science, which explains this sort of global way of regressive politics as a product of effects of broad economic transformation that create losers, meaning all this work on the effects of globalization, the effect of technological change, well, the losers, the so-called left behind, drive the backlash. This scholarship has actually gotten very sophisticated in also trying to explain some of the mechanisms through which economic grievance turns into broader conservative worldviews and, a broader participation on this very broad notion of the backlash that I'm interested in. For the EU, of course, this has sort of immediate implication because at stake, there was a sense that this will delay or sort of block some much needed transformations like the green and digital transition, but also, the internal market as an emancipatory project, if you want, was also threatened by this wave of sort of far-right politics. So what I intend, the observation was that despite we have all this body of scholarship which makes the connection between economic transformation and backlash, there was to some extent a limited understanding of how loss linked to this economic transformation is experienced, interrelations between various components of this loss, and indeed how it spillovers from economic to other fields, because the narrowly more economic grievance turns into a broader conservative worldview. How does that happen? And how whether the law can do something to both attend to this loss, talk to these losers, and then remedy through some form of accommodation. That's the sort of project. And the hypothesis that better understanding of his experiences of loss linked to economic transformation and how law can govern it ultimately can shape more just economic transformations. So the idea is like, we don't want to just deal with the losers, but let's say listening to the losers fundamentally also transform the policy, the direction of the economic transformation. So in a way, it's a sort of moves beyond there is a lot of work in this field, for example, in the tradition of law and economics that tries, how do we sort of ensure the transition to a better stage by compensating the losers. So it's beyond the idea of compensation. There is an idea of sort of transformation also of the thing. And conceptualizing loss, well, indeed, in the political science, there is an idea that sort of, yeah, the losers lose, the left behind lose. My initial definition is a bit more, let's say, phenomenological, just like, but you know, what happens? What happens is, to me, the idea that economic transformation makes go away long-standing and habitual forms of production and distribution arrangement. So that people are attached to it in many different ways. And the drivers of what creates this displacement are various, right? One of them is globalization, trade liberalization, technological change. Now it's huge with sort of digitization and AI, but also climate change and efforts to mitigate it. And there I know it's like you bundle together both climate change. Yes, because sort of what I'm interested in is both climate, you know, for example, biodiversity loss and efforts to mitigate it can produce these, let's say, loss of forms of market organization that is important to people. So these losers are those workers, business, and consumers who rely or simply just value displaced arrangement for their income, livelihood, but also sociability and community. And in this very broad definition, there is this idea of these various facets of loss: losses, material and immaterial component, individual and collective, private and public. And also, it's not only linked to work, but consumption, meaning, you know, we're not only losers as workers, but, you know, we may lose insofar as, yeah, we lose on habitual ways of participating in markets, or we lose a market experience, so to say. So this very broad conceptualization has implications because, you know, then also the theorizing of the legal strategies happens from areas of the law which are disparate. It's not just labor law, the welfare state, but it's also, for example, competition and consumer law. I'll say something about that. Well, you know, of course, another important observation, I mean, I don't know exactly what I'll do with it, but I think it's important, is this loss doesn't happen everywhere, right? Sort of, if you live in Amsterdam, you sort of experience very little of this loss probably. And even sort of epochal change like AI uptake may displace your job, but, you know, you're going to have other resources. That's my intuition, right? So the loss somehow is concentrated, localized, so, and these experiences are place specific, and it's most intense where different drivers of the transformation coexist and affect sort of have an impact in a specific place. And this again is a sort of very preliminary sort of observation, but, you know, less economic diversification, of course, makes individuals and communities more vulnerable. So this would be an indication of where losses experience more intensely. And of course, there is much literature from different areas here, geographies of centrality, the works on democratic decline, the work of Catherine de Vries, who has studied this very much from the political science, focused very much on public service deprivation as one of the mediator, you know, the things that transform the economic grievance and augment it into a broader sort of, say, view and challenge to liberal values, so to say. These are some of the cases which I intend to study, and, you know, they seem small, they're very place specific. So yeah, here I have to be careful, but the idea is like, yeah, some of these things are very place specific. So, you know, this would be biodiversity loss, you know, makes a type of fishing goes away in Italy, and they, you know, what's the loss there? Of course, will have some of those components that is not just loss of a job, it's loss of community, loss of meaning, and then, you know, it spills over from the economy to the family, and also in this relation to specific, I will have to map, but there is a lot of law that intervenes, right? Different areas of the law tries to have a bearing on this type of experiences. So that's the type of law that I want to study to then conceptualize this idea of governing laws, which I'll go to in a minute. Of course, another prominent example, you, James, I don't know if this was one of your studies, but, like, you know, of course, the backlash to plans to reduce the number of livestock in order to comply was the plan for the Netherlands to comply with EU biodiversity laws, the Habitats Directive. Again, here, very, at this level, it's more journalistic account. The way this is described, it's a very sort of complicated. It's not, the grievance is not just, I'm going out of business. It's a sort of a whole way of life, meaning that goes away. And this is work instead I've done work with on this. It's here it's very explicit to say the link between EU-induced trade liberalization, the Services Directive, and laws. It's about Italian beach concessions, where these were renewed really in violation of all sort of idea of openness and competition rules, and indeed also here there are these sort of features of laws that I observed when I interviewed some of these beach concessionaires. They immediately start talking about families, start talking about the customers. So, the losers to some extent. And of course, one needs to take this narrative with a grain of salt. They're politicized and everything. But the idea is like, these are the type of case studies that illustrate this. On governance of laws, what is the idea? Well, the idea is, of course, legal programs, legal techniques that, let's say, attend to these are possibly ubiquitous, right? We'll find them in many areas of the law, rules that are attuned to protect individuals in the face of rapid change. And I'm trying to describe them all together to the sense of governance of laws, to identify successful strategies. And the intuition is successful strategy will contribute to more just market transformation and also sort of alleviate the backlash intended as this sort of broader reaction to liberal values to some extent. What's in this governance of laws or governing laws? Well, there are some substantive accommodations like compensation and reskilling. They're part of the mainstream of the welfare state. And of course, these are, I will have to describe, but it's much broader. My intuition indeed is that many areas of law, like consumer law, competition law, the common agricultural policies, have this type of interventions geared to assisting losers. And here, for example, I've studied myself rules that seek to protect incumbents in retailing or sort of small shops in retailing. And, it's a very vast body of rules that have this functionality. Or in consumption rules that seek to protect consumers by ensuring there is, a variety of retail channels, online, supermarket. So all of these sort of preserving plurality in the face of transformation is a governance of law strategy that I think is important. And indeed, these are also legal techniques that slow down the pace of change, soften the blow, preserve a plurality of economic arrangements, as I say. And of course, there is important regulation and governance part of the story, which is not only substantive accommodation, but a large part of the success is sort of procedural or participatory mechanisms that allow to identify these laws, understand what the grievance really is, and intervene also to some extent in real time. Of course, I'm aware of all the sort of concerns about, who gets to participate and power, but yeah, this is the initial conceptualization. I had something else to say about the EU, but I'll stop here and maybe we can just do it.
Maybe I can. Thank you.